Welcome to Divorce Parenting and Property Legal Insights from Village Family Lawyers. Today, we're talking about property settlement negotiations, and in particular, what people often get wrong in the early stages, sometimes without even realising negotiations have started. Many people assume property settlement negotiations only begin once lawyers are involved or formal steps are taken. In reality, they often start much earlier, sometimes in the days or weeks following separation. A suggestion is made about the house, a conversation happens about money, an agreement is floated just to keep things calm. These early discussions may feel informal, but they can shape expectations and outcomes long before anyone realises what's happening. This is especially common after an unplanned separation. One person may still be processing the emotional impact, while the other is ready to talk about practical outcomes. That imbalance alone can influence how negotiations unfold. One of the most common mistakes we see is people treating informal discussions as harmless. Statements like, "we'll sort it out properly later," or "this is just temporary," can quickly turn into expectations that are difficult to shift later, even when circumstances change or more information comes to light. Another common issue is agreeing to outcomes before the full financial picture is clear. This often happens where one person has managed the finances or where there are businesses, trusts, superannuation, or debts involved. Without a full understanding of what exists, it's very difficult to assess whether a proposed division is fair or sustainable. Power imbalance is another factor that can quietly influence property settlement negotiations. This might involve financial control, emotional pressure, differences in confidence, or long-standing relationship dynamics. In these situations, agreements can appear mutual on the surface while being driven by pressure underneath. It's also very common for people to want negotiations to end as quickly as possible. Separation is emotionally exhausting, and uncertainty can feel unbearable. But rushing to an agreement can create financial stress later, particularly when housing costs, living expenses, and long-term needs haven't been fully considered. Another misconception is that fairness always means an equal split. Under Australian family law, property settlements take into account contributions, future needs, care of children, health, age, and earning capacity. Without understanding how these factors apply, early agreements can overlook important considerations. Seeking legal advice early does not mean escalating conflict or heading to court. In many cases, it actually reduces conflict. Early advice can help you understand your position, identify risks, and approach negotiations with more confidence and clarity. At Village Family Lawyers, we regularly assist clients before formal property settlement negotiations begin. They are not looking to argue or take drastic steps. They simply want to understand where they stand and how to move forward without creating problems later. If this conversation resonates with you or with someone you care about, you're welcome to get in touch with us. Our website is villagefamilylawyers.com.au and our phone number is 1300413997. This has been Divorce, Parenting and Property Legal Insights from Village Family Lawyers. We're here to help you take the next step when you're ready.